My name is Justin Ziegler. I'm an attorney with JZ Helps, an injury law firm in Florida. And today I'm going to talk about whether a pedestrian has a case if they're hit by a car in Florida. This entire talk assumes that the driver that hit the pedestrian was somehow at fault for the crash. What types of compensation can a pedestrian get if they're hit by a car? Can generally get the same types of damages, otherwise known as compensation, as any other accident in Florida. Okay? I'm not going to go over all 14 or 15 types of damages, but just understand you can get your out-of-pocket medical expenses paid, lost wages that you don't receive, and money for pain and suffering. Again, this all assumes the driver was at least partially at fault or totally at fault, and I'll get into that a little bit later. I wrote a separate article on how a pedestrian can get his or her medical bills paid after a car accident in Florida. I just want to hammer this point home. A driver needs to be at fault in order for a pedestrian to get money for pain and suffering, out-of-pocket medical bills, lost wages, and other types of compensation. So what are the common types of pedestrian accidents where a pedestrian ends up receiving money for their damages? This is a mid-block pedestrian crash. It's one of the more common types of accidents. And as you can see, the pedestrian is not in the intersection. There's a car proceeding. They hit each other. The car strikes the pedestrian. Now again, I've talked about the fact that the driver needs to be at fault in order for the pedestrian to get any money. Here is the driver at fault? Possibly. As you can see, the driver is in the most interior or inside lane. Arguably, he or she had some more time to see the pedestrian walk across the street. But you can also see that the pedestrian is not in an intersection, so the pedestrian is going to have a large amount of fault. And one of the things you do when evaluating the full value of the claim is you say, first, is the driver at fault? We'll assume yes, at least somewhat for this accident. But then you say, is the pedestrian at fault also? And the total value of the compensation that a pedestrian would normally be able to get, you subtract the percentage of negligence or fault on the pedestrian. So in this case, let's say the pedestrian was 75% at fault. You would take the full value of the case and reduce it by the pedestrian's fault, which is 75%. In other words, the pedestrian gets 25% of the full value of the case. I wrote an article there's a link there that you can link to it, that you can click to, and it's about that exact type of accident, and it goes into much more detail. Is a driver at fault for hitting a pedestrian who's passing out flyers like this gentleman at the intersection? Possibly. I wrote a separate article on that because these pedestrian cases are very, very, very fact-specific. The amount of compensation that you may get turns on the individual facts. But just understand that a driver may be at fault for hitting a pedestrian who's passing out flyers. The pedestrian may have a tremendous amount of fault because they should not have been in the middle of the road passing out flyers, but there's a separate article and video soon to come on that. After we established if the driver's negligence or carelessness was the cause of the pedestrian getting hurt, was the cause of the accident, we look at, did the accident cause the injury? Now, in some cases, it's going to be fairly straightforward, such as a pedestrian has a fracture, a broken bone, or has surgery, or bleeding of the brain, or something of that nature. It's easy to link up the injuries to the crash. But when you start to deal with a shoulder tear, or my shoulder hurts, or shoulder pain, the cases can become tougher, particularly if you're dealing with older individuals who may have acquired those injuries over the course of their life. So assuming you can show that the driver's at fault and their fault caused the injuries, you then look at what are the pedestrian's out-of-pocket medical bills. And generally, the pedestrian's entitled to recover their out-of-pocket medical bills. But again, you go back to looking at the fault of the driver. So if the pedestrian's out-of-pocket medical bills were $10,000, but the driver was only 20% at fault, the pedestrian will only be able to recover $2,000 for those out-of-pocket medical bills. 20% of $10,000 is $2,000. That is a very, very basic explanation of out-of-pocket medical bills. I wrote an article specifically on the type of insurances that may pay for the pedestrian's medical bills. Understand that it really, really can get very complex. I'm keeping it very simple here now. In regards to money for pain and suffering, mental anguish, loss of enjoyment of life, inconvenience, generally speaking, although there are exceptions, the pedestrian needs to meet what's called the tort threshold. The injury the pedestrian must meet the tort threshold in order to even get 1 cent or more for pain and suffering. That's why I have the word forever. The injury needs to be permanent. Now, the good news is for an injured pedestrian, that standard may seem much higher than it is. Now, if the case gets to a jury, which most cases don't, that standard is relatively high. But most cases settle before a lawsuit, which is the good news for pedestrians who are hurt. How does a pedestrian meet this tort threshold? And what is the tort threshold? The tort threshold is a certain limit, type of injury a pedestrian must have in order to get 1 penny for either past or future pain and suffering. The most common injury that meets the tort threshold is someone who is permanently injured within a reasonable degree of medical probability, which means a doctor needs to testify that your injury is permanent. If you have a scar, permanent or significant scarring or disfigurement, that meets the tort threshold as well. And obviously, God forbid you die, that meets the tort threshold as well. If you happen to lose your spleen, for example, that would meet the significant and permanent loss of important bodily function. But just keep in mind, you just need to meet one of these types of injuries. Good news for out-of-state visitors heard in Florida is if you're from out of state and you don't have access to PIP, you do not have to meet the tort threshold, have a permanent injury in order to get money for pain and suffering. So that can really increase the value of an out-of-stater's claim, an out-of-stater and a pedestrian from out of state, the value of their case. If the out-of-state pedestrian does have access to PIP, even if it's from the outer state, I think he does not. I think he needs to have a permanent injury in order to get money for pain and suffering, even 1 penny. You want the doctor to state in your medical records, if true, the injury you have is permanent. Although some insurance companies will pay you even without a doctor saying, and when I say pay you, I mean pay you for money for pain and suffering, even without a doctor saying that your injury is permanent. This usually happens in claims where you have a fracture or your medical bills are very high. You want to hope that liability insurance is available. Unfortunately, in Florida, about 1 out of 5 drivers, I believe the statistic is, do not carry bodily injury liability insurance. We're going to assume right now that the driver's at fault and the driver caused your injury. How much money can you get? This is going to depend on the facts of the case. I was able to settle a case for pedestrian hit by a car for $325,000. He broke the lower part of his leg. He was hit while putting a parking ticket into his car, and a car hit him, and we were able to settle that claim for that amount. He had surgery, which generally drives up the value of the damages significantly. I also settled another case for a pedestrian for $110,000. She was walking in a crosswalk hit by a car. Had she not been walking in a crosswalk, the case may have been worth half that amount or less, depending on the particular facts. She fractured the bone right here in her face. She had an orbital fracture. Also recently settled in 2016 a case for a pedestrian hit by a car while not in the crosswalk. She was right there. She stopped to retrieve a hose, walk this way, turn back, a car in this lane hit her. We received $70,000. She had some bulging discs. They may have been pre-existing before the accident. She had a tibial plateau fracture, which is a fracture right below the kneecap. She also had a sacrum fracture, which is the low end of the spine, and a shoulder injury, shoulder impingement, and herniated discs. Many of those injuries may have existed before the accident. This is not my case, but I want to point out that there was a pedestrian hit and killed by a Publix truck. His case was dismissed. Now, the good news is if you're a pedestrian, your case generally does not get dismissed. It generally makes its way to trial if you were hit by a car. In this case, a pedestrian was in Punta Gorda, Florida, and was hit by a Publix truck. Publix is one of the larger supermarkets, actually the largest supermarket in Florida. The estate made a claim for pain and suffering, which is generally the largest part of a wrongful death case, loss of support, and funeral expenses. The problem with this case, and one of the reasons why it got dismissed, the pedestrian was allegedly illegally crossing the interstate. If you're crossing I-95, which is a major interstate in Florida, or the Palmetto, or the 836, these are all major roads. If you're crossing one of these roads and you're hit by a vehicle, your case is extremely tough. The exception is if you're hit by an 18-wheeler. 18-wheelers and tractor trailers are subject to so many regulations that they still may share some fault. Now, the pedestrian's family, who sued for him, the estate, the personal representative, had some defenses. They said that there were skid marks showing that the truck driver should have had time to avoid the accident. Some of the things that made the case very tough and resulted in the dismissal: the pedestrian was let out of jail shortly before the accident, and although that may be inadmissible in the case, it's generally not a very strong fact for the pedestrian. He was also allegedly drinking alcohol in Florida. The pedestrian likely wasn't married. I say that because the parents were able, or at least made the claim for pain and suffering. If a pedestrian is unmarried at the time of the accident, the parents and the children both have a case for pain and suffering if the pedestrian is killed in the accident. And again, the driver needs to be at fault. In Florida, a pedestrian has no case if he's hit by a car and the pedestrian is 50, if his intoxication, his drunkenness in this case, resulted in more than 50% of his fault in the accident. Now, if you're drunk and you're walking through a crosswalk, the car is still at fault, even if you're totally intoxicated.